Okay. So today we are supposed to start this chapter 3, obligations of providers and developers and deployers of high risk AI systems and other parties. Now what can be other parties? Without looking here, they can be authorized representatives, importers, distributors, what else? Right, so mostly these things. So authorized representatives, distributors, importers, anything that I have left out here? Because you already have providers and deployers here. I think that's it, but let's see. Okay. So now in chapter 2, what did we talk about? In chapter 2, we talked about requirement of high risk AI system. Right? What are the obligations of providers and other parties now? So article 16, obligations of providers of high risk AI systems. So providers of high risk AI systems shall, what does the term shall mean in legal text? It's an obligation, you should comply with this, okay. Ensure that their high risk AI systems are compliant with the requirements set out in the chapter 2 of this title. So the very first requirement, very first obligation of a provider is what? Yes. So what is the very first requirement or obligation of the providers of high risk AI? They should be in compliance with which requirements? Requirements provided in chapter 2. What was chapter 2? I should have kept an exam. क्या बोल रहे हो? Right. So what was chapter 2? Remember those requirements: risk management system, technical documentation, cyber security, and all those things. Okay. So chapter 2 requirement should be complied with. Now the providers should indicate the whereabouts of the provider. So indicate their name, registered trademark, registered trade name, address that can, on which they can be contacted, and so on. And where it is not possible, on its packaging or its accompanying documentation as applicable. So in a nutshell, all this says is whereabouts of the providers have to be provided. So whosoever is providing the AI, high risk AI, right, their name and everything. Remember, here we have providers of high risk AI systems shall. So providers of high risk AI system shall have a quality management system which complies with article 17. Right now we are at which article? We are at 16, right? So the 17 is yet to come. Then keep the documentation referred to in article 18. We have already talked about a kind of documentation. This was in which article? Remember, we talked about technical documentation in article 11. Now this opens a Pandora's box when under their control. So what is the line before this? What is the text preceding this part? So providers, the providers of high risk system shall, when under their control, keep the logs automatically generated by their high-risk AI systems as referred to in Article 20. Now, when under their control, to me this is a, how do you define when are things under the control of a provider, when they are not? It's a very, very gray area. Providers shall ensure that high-risk AI system undergoes the relevant conformity assessment procedure provided to in Article 43 prior to its placing on the market or putting into service. So, what was conformity assessment? We have talked about all this. Draw up an EU declaration of conformity in accordance with Article 48. So, there is not much to explain here. Affix the CE marking on the high-risk AI systems to indicate conformity with this regulation in accordance with Article 49. Compliance with the registration obligations referred to in Article 51. Take necessary corrective actions and provide information as required in Article 21. What is this part? Can you explain me? Upon a reasoned request of a national competent authority, demonstrate the conformity of the high-risk AI system with the requirements set out in Chapter 2 of this title. What is this part? Who should demonstrate the conformity? Provider. To whom? To a national competent authority. Okay. And with what? With the requirements set out in Chapter 2 of this title. Now, important part here is, are providers supposed to do it for any request that is coming from these authorities? No. So, it is important here that it has to be a reasoned request, right? You can't just ask me anything. Whatever you are asking for, it has to be a reasoned request. So, this is an important thing here. Now, ensure that the high-risk AI system complies with the accessibility requirements. What this essentially means is accessibility of the websites and mobile applications of. So, basically you are supposed to comply with the accessibility requirements too. So, not too much to understand here except from the fact that this is a procedure that the providers have to comply with. Now, Article 17, quality management system. Providers of high-risk AI systems shall put a quality management system in place that ensures compliance with this regulation. That system shall be documented in a systematic and orderly manner in the form of written policies, procedures, instructions, and shall include at least the following aspects. See, a strategy for regulatory compliance, techniques, procedures, and systematic actions. Techniques, procedures, and systematic actions. So, to do what? To be used for the design, design control, and design verification of the high-risk AI systems. To be used for the development, quality control, and quality assurance of the high-risk AI system. Examination, test, and validation procedures to be carried out before, during, and after the development of AI systems, and the frequency with which they have to be carried out. What is this? Part D. See, what is this article talking about? What were previous articles talking about? What was Article 16? obligations of the providers. Okay, what are the obligations? These are mostly procedures. You have to comply with article 17, 18, 20, why not 19? Because 19 is not there in this draft, it is deleted. 21, 43, 48, 49, 51 and so on. Okay, all they are telling is the providers of high risk system shall do all these things that is mentioned in different articles. Now, in the same article itself here, in article 16 here itself, if you see, they say so who should have a quality management system? Providers, which complies with article 17. So right now we are talking about providers and we are talking specifically about this. From here we go to article 17 now. So article 17 mandates a provider to have a quality management system. A provider of what? Any AI system? High risk AI system. So this is something that you have to keep in mind. Providers of high risk AI system shall put a quality management in place that ensures compliance with this regulation, which essentially means chapter 2 primarily, and of course all these things as well. That system shall be documented in a systematic and orderly manner in the form of written policies, procedures, instructions, and shall include at least the following aspects. Now see, people talk about regulatory or the compliance cost. What does it actually mean? When people talk about compliance cost, what does it actually mean? No, you won't find it here. See, what compliance cost, see, you see all this burden. So before you are able to put high risk AI on the market, you are supposed to comply with all these things. So for example, what does it say? That system shall be documented. Which system? The quality management system shall be documented in a systematic and orderly manner in the form of written policies, procedures and instructions, and shall include at least the following aspects. So this is, it is mandate to have all these things. Strategy for regulatory compliance. So you need some dedicated people who are just looking for these compliances, including compliance with conformity assessment procedures and procedures for the management of modifications to the high risk AI system. Now, techniques, procedures and systematic actions to be used for design control and design verification of the high risk AI systems, and for the development of quality and quality assurance. Now, I will stop here. Examination, test and validation process to be carried out before, during and after the development of high risk AI system, and the frequency with which they are. So what is it that you have to examine, test and validate? So examination, test and validation procedures to be carried out before. So before is important here. Before, during and after the development of the high risk AI system. So development is important here, and the frequency with which they have to be carried out. Why have I underlined development here? Right. So you are supposed to do all these things that are mentioned here before deployment, and of course before placing it on the market. So you have to do all these things before you even place your AI on the market. Technical specifications including standards to be applied, and where the relevant harmonized standards are not. So basically all this says technical specifications including standards to be applied, and where the relevant harmonized standards are not applied in full or do not cover all of the relevant requirements set out in chapter 2 of this title, the means to be used to ensure that high risk AI system complies with those requirements. What is this now? More or less, but something more. See, where the relevant harmonized standards are not complied in full or do not cover all of the relevant requirements set out in chapter 2 of this title. So this was important here. Do not cover all of the relevant requirements set out in chapter 2. So if you do not cover all of this, then the means to be used to ensure that the high risk AI system complies with those requirements too. Okay. So we have seen that there is absolutely no bypassing to title 3 chapter 2, where you mention all the requirements of a high risk AI. Systems and procedures for data management, including data acquisition, data collection, data analysis, data labeling, data storage, data filtration, data mining, data aggregation, data retention, and any other operation regarding the data that is performed before and for the purpose of the placing on the market or putting into service of high risk AI systems. And we come so far that we have even forgotten what was the line here. So that system and shall at least include the following aspects. So you are supposed to make a quality management system in which you are supposed to document in a systematic and orderly manner in the form of written policies, procedures and instructions, and shall include at least the following aspects. So we have talked about this now, systems and procedures for data management, including all this regarding the data that is performed before and for the purposes of placing on the market or putting into the service of high risk AI systems. So this is the list of what? This is the list of those things that should at least be complied with. So when the system shall be documented in a systematic and orderly manner in the form of written policies, procedures and instructions, and shall include at least, so these written policies, procedures and instructions should include at least these aspects that we have talked about and about the systems and procedures for data management. So you are having a quality management system that is mandatorily supposed to have all these points. One of them is the systems and procedures for data management. Now they say including all these things regarding the data that is performed before and for the purpose of placing on the market or putting into the service of high risk AI systems. The risk management referred to in Article 9. The setting up, implementation and maintenance of post-market monitoring system in accordance with Article 61. The procedures related to the reporting of a serious incident in accordance with Article 62. So there is a serious incident that they define in Article 3. I am not going there. Procedures related to, so there are some kind of incidents which are very serious in accordance with Article 62, or we can just go. So this is what serious incident means. So serious incident means any incident or malfunctioning of an AI system that directly or indirectly leads to any of the following: the death of a person or serious damage to a person's health, a serious and irreversible disruption of the management and operation of critical infrastructure. We have seen what critical infrastructure is. Breach of obligations under union law intended to protect fundamental rights, and serious damage to property or the environment. So this is what we mean by serious incidents. Let's go back to where we were. The handling of communication with national competent authorities, other relevant authorities, including those providing or supporting the access to data, notified bodies, other operators, customer or other interested parties. What is this? What are we supposed to do with this? So there is a quality management system that this particular article mandates, and it says that you should talk about at least these points. So, and what were those three things? Remember, these written policies, procedures and instructions. So this quality management system shall be documented in a systematic and orderly manner in the form of written policies, procedures and instructions, and shall include at least of the following aspects, under which you have these things. So, handling of communication with national competent authorities, other relevant authorities including those providing or supporting the access to data, notified bodies and other operators, customers, interested parties. Systems and procedures for record keeping of all relevant documentation and information. So, systems and procedures of record keeping of all relevant documentation and information. No, by the way, these things have been very difficult for even EU to manage. So, GDPR they have found was very difficult to enforce. You can't easily enforce these digital things in digital space.
मतलब ऐसा तो है नहीं कि इनको कोई कैपिटल गेन हो रहा है या फिर कंपनीज को कोई लॉस हो रहा है तो इनको उससे गेन हो रहा है.
See, the point is, so I mean, I agree with this. In my opinion, I think they are over-regulating. Regulation of AI is required, but in my opinion, they are over-regulating.
मतलब मोटो क्या है उसके पीछे का ओवर रेगुलेशन.
No, we know what was the motto. बात तो नहीं करो कम से कम. Yes. So, resource management including security of supply related measures and accountability framework, setting out responsibilities of the management and other staff with regards to all aspects listed in this paragraph. Now, you have listed so many things which are on your mandatory list. And what were you doing? There was a quality management system that was supposed to talk about the written policies, procedures and all these things. So, regarding all these things, you should have written policies, procedures and all those things. Okay. Implementation, now paragraph changes. So, implementation of aspect referred to in paragraph 1 shall be proportionate to the size of the provider's organization. So, at least some breathing space. If you are a small company, then it has to be proportionate to the size of the provider's organization. Providers shall in any event respect the degree of rigor and the level of protection required to ensure compliance of their AI systems with this regulation. So, some breathing space given and then most of it taken back. So, providers shall in any event respect the degree of rigor and level of protection required to ensure compliance of their AI systems with this regulation. Now, for providers of high risk AI systems that are subject to obligations regarding quality management systems or their equivalent function under relevant sectorial union law, the aspects described in paragraph 1 may be part of the quality management system pursuant to that law. What does this mean? What does this mean? All this says is, if you are complying some other law, okay, and if that is enough, so you just comply with that law. For providers that are financial institutions, you have Union Financial Services legislation, comply with that, and whatever remains, okay, only for that part, comply with this. Article 18, documentation keeping. The provider again shall, for a period of ending 10 years after the AI system has been placed on the market or put into service, keep at the disposal of the national competent authorities a technical documentation referred to in Article 11. What was Article 11? Article 11 was in which chapter? थोड़ा सा इन्वॉल्व हो भाई, ऐसे लुक देते हो तो मेरे को भी डर लगता है फिर. हाँ, क्या बोल रहे हो? याद नहीं करना है हमको. So we are not supposed to, by heart. We are just trying to see. The reason I am covering this part is, so the takeaway of this will be as per your convenience, but my takeaway is they are over regulating it. So in whichever company, let's say you go, if they want to deploy something in EU, so that at least you should be aware that deploying it in EU, you have a mountain ahead, which is not technical but regulatory. So the purpose of doing whole this thing is this, that's it. And we don't really need to know the exact details of this mountain right now, just that it's a daunting task, that's it. So documentation keeping, see, documentation, we have seen so many documentations. We have seen a documentation article 11. So what is this documentation? So providers shall, for a period ending 10 years after the AI system has been placed on the market or put into service, keep at the disposal of the national competent authorities. Now I don't know how many of you will agree, but whatever AI application you are using today, 10 years in AI applications is a huge time. They don't even survive for 10 years in the way they were deployed. Right? They change very quickly. So, but anyway, you have to keep the technical documentations referred to in Article 11 and Annexure 4 as we have seen. The documentation concerning the quality management system referred to in Article 17 that we just saw. The documentation concerning the changes approved by the notified bodies wherever applicable. So you wanted to make some changes in your high risk AI system, right? Wherever those changes were approved by the notified bodies. What are notified bodies? This is chapter 3. Chapter 4 talks about notified bodies that I won't talk about. The decisions and other documents issued by the notified bodies wherever applicable. The EU Declaration of Conformity referred to in Article 48. So each member state shall determine the conditions under which the documentation referred to in paragraph 1 remains at the disposal of the national competent authorities for the period indicated in that paragraph for the cases where provider or authorized representatives established in its territory goes bankrupt. Okay, I should have not read all this. Just one thing was enough to read, which was, see, so providers may not even survive for 10 years. So whichever comes first, 10 years or it goes bankrupt. Okay. Now providers that are financial institutions. So this is something you should be able to see by now. If whatever you are doing, if your company is not already covered by existing legislations of EU, then you have to comply with this in full. But if you are already things like financial institutions, then they are already covering a lot of what is provided here. Okay. Automatically generated logs. So they used, when we were doing BTech in electrical engineering, there used to be a course, automatic control systems. Okay, and students used to ask this question, if this is automatic, why are we studying it? Now the same thing here, automatically generated logs. This is happening automatically for whom? For those who are making these legislations, but for the development, for the developers part, this can be a really painful thing. In particular when you apply phrases like to the extent such logs are under their control. Developers control, providers control, right? But what does it even mean as a computer scientist? I don't understand. To the extent such logs are under their control, because in the end you can code every damn thing. Okay? So in the end you can code every damn thing. What does it mean to say to the extent such logs are under their control? and who is going to judge my company for this if I violate, let's say, this part? So providers of high risk AI systems shall keep the logs referred to in Article 12 automatically generated by their high risk AI systems to the extent such logs are under their control. Without prejudice and applicable union or national law, the log shall be kept for a period appropriate to the intended purpose of the high risk AI system of at least 6 months unless provided otherwise in applicable union or some other law, in particular personal data. Providers that are financial institutions, those regulations apply. So wherever you see this phrase, providers that are financial institutions, those regulations apply. Article 21. So Article 17 was, so Article 16, 17, 18, 19 is deleted, 20, we are talking about 21, they are all about which party? They are all about providers. Corrective actions and duty of information, what might this article have? So if providers consider or have a reason to consider that their high risk AI system is not in conformity, then you have to take corrective actions and you have to inform some authority. So providers of high risk AI systems which consider or have reasons to consider, again if you see the legal language, you will always see things like this. So what difference might it make? Providers of high risk AI systems which consider or have reasons to consider. What is the difference between these two? Which consider or have reasons to consider? Okay, more? No, there is more to it. I mean, I don't think I necessarily accept that example. Yes, देखो, let's say this phrase is not there or have reasons to consider. Okay, providers of high risk AI systems which consider that a high risk AI system which they have placed on the market or put into service is not in conformity with this regulation shall immediately take the necessary corrective actions to bring that system into conformity, to withdraw, to disable, to recall it as appropriate. So how can a provider bypass this if I just remove this or have reason to consider? See, I reread this. Providers of high risk AI systems which consider that a high risk AI system which they have placed on the market or put into service is not in conformity with this regulation. So if I remove this, what happens? If I just say providers of high risk AI systems which consider that a high risk AI system that they have placed on the market is not in conformity. So a provider can come and say, I did not consider that is not in conformity. I did not consider, right? So what is this phrase doing? You did not consider, fine. But since you knew this, and hence you had reasons to consider that this is not in conformity. Okay, so you can't really bypass laws. All such phrases are there to stop such mitigations. Where the high risk AI system presents the risk within meaning of Article 65(1). Now Article 65(1) is things that pose threat at a national level, at a much bigger level. Cooperation with competent authorities. Providers of high risk AI systems shall, upon a reasoned request, if you see most of the places they are saying reasoned request, no authority can come and ask you for anything just like that. It has to be a reasoned request. To provide that authority all the information and documentation necessary to demonstrate the conformity of the high risk AI system. Resend request means, so let's say you are the provider, I as authority come and ask you for something. If I give you reason and if you are satisfied, then you do whatever. The problem is only when you are not satisfied with the reason. So there is a dispute, and such disputes are resolved by a court of law. So in laws, you deliberately, legislators, they put such statements which will be decided by a court of law and cannot be written, this side or that side in that particular text itself. So basically you have to comply with the cooperate with the competent authorities. You are supposed to also give them access to the logs referred to in Article 12.1, which were the automatically generated logs. To the extent such logs are under their control, I don't even understand what does this mean. Any information obtained by a national competent authority pursuant to provisions of this. So somebody was asking me this question, what if the authorities, they start using my AI systems, right? So there has to be a confidentiality obligation on those parties as well. They simply can't do anything legally. So providers' obligations are over. Okay. Now we talk about the authorized representatives. What might be the obligations of authorized representatives? बिना देखे बताओ. Right. So authorized representative will be for which provider?
Which are based outside of the country.
Outside EU, right? So those providers who are inside EU, Article 25 is not applicable because those who are inside EU, Article 25 is not applicable because they are inside EU, and articles, the previous articles, they are applicable to them. So prior to making their systems available on the union market, providers established outside the union by written mandate appoint an authorized representative which is established in the union. This we have seen before in the definition itself. So this is the last article, but that is pretty long. But we won't take too long. The provider shall enable its authorized representative to perform its task. Trivial thing, that is why they have this authorized representative. The authorized representative shall perform the tasks specified in the mandate received from the provider. It shall provide a copy of the mandate of the market surveillance authorities upon request. In one of the official, now see this, yet another thing. In one of the official languages of the institution of the union determined by the national competent authority, for the purpose of this regulation, the mandate shall empower the authorized representative to carry out the following task. So you are supposed to provide information to these authorities in the language they prefer. So if France asks you in French, you are a company based in India, supposed to give an information to that authority in French. Okay? Or, of course, English will be accepted because they won't want this language barrier to be there, but at least in principle, you might have to provide it in different languages for different EU countries. Of course, this will not be a barrier, but if the authorities want to make a barrier, they are permitted by the law. Verify that the EU declaration of conformity and technical assessment. So basically, I won't repeat. What will be the obligations of authorized representative? They will be same as of, most of them will be same as of providers, not all. Okay. So You have to demonstrate the conformity with high risk AI system. You have to provide the copies of all these things, the technical documentation, declaration of conformity. You have to cooperate with competent authorities. We have seen such article for providers. Wherever applicable, comply with the registration obligation.
सर
Yes.
सर फिर ऑथराइज्ड रिप्रेजेंटेटिव और उसमें प्रोवाइडर में डिफरेंस क्या है? जब अपन प्रोवाइडर की बात करें तो डेफिनेटली कोई उसे रिप्रेजेंट करेगा होगा।
Yes.
सर फिर ऑथराइज्ड रिप्रेजेंटेटिव की अलग से
No. See, first of all, not all of providers is repeated. Second, authorized representative means your company is not established in the EU. It is in India. Right? If you were a provider inside EU, then this is not applicable to you because you are in the EU itself. But if your company is outside, then you have to have somebody inside EU with a written agreement, written mandate. Okay? And the authorized representative shall terminate the mandate if it considers or has reason to consider that the provider acts contrary to the obligations under this regulation. Okay? So, one article for authorized representatives and next one is for importers. We will do this in the next class.